Hello. At yesterday's hearing, there was less than 5 to 7 minutes. I would imagine 5 to 7 minutes, which was actually even less time than what I spent when I was allegedly entered into observation for a mental health assessment in March of 2017. It was approximately that amount of time, it was approximately that amount of depth, and it was approximately that amount of dumbfoundedness in terms of what they actually considered in terms of what was going on. But I did prepare. Not only did I have an affidavit, including an affidavit that cited various aspects of the Texas rules of civil procedure, specific to justice courts, that also allowed for an understanding that the affidavit itself could be used in consideration of bond should there be an appeal. And I also composed an argument, a very brief summary, as well as 2 pages worth of evidence that would have been submitted. So first I'm going to start by entering into evidence that which was to be listed as evidence yesterday. First of all, there was a letter from the IRS, tax notice dated February 26th of 2020, which was followed up with a phone call in the first week of March of 2020. January 19, 2021, postmarked notice of transaction dispute for job from August of 2020. Regarding a August 7, 2020 memo that was submitted to the employer. And also in consideration of the original request that had been provided January 7th of 2021, wherein I disputed that specific transaction. March 16th, 2021, postmark regarding notice concerning the dispute resolution. Their indication was that they concluded an error had occurred, and as a result, there was a credit posted to my account on March 15th of 2021. This also includes a tax return first filed on February 12, 2021, electronic notification that it had been accepted. However, sometime later, the indication was that it had not been posted. There was no evidence any longer that it had been accepted. I have the evidence as is. So I had to resubmit my tax return on March 10th of 2021. March 23rd of 2021, I attempted to pay the amount I was told I was required to pay as part of the alleged tax that was owed, as opposed to actually receiving what I understood would be my tax return. I set up an account with the IRS to receive information on March 25th, 2021. That original effort to pay was not accepted, it was declined. Another effort on May 10th, 2021, where I attempted to pay that $12, was identified as the transaction had been received, but on May 11th, 2021, the payment was declined. There was no reason. Also submit forms regarding business tax being paid on March 13th of 2021, accepted as paid and confirmed on March 23rd of 2021. There are also letters from the IRS regarding past due notices, one dated for April 5th of 2021 at $12, one dated for July 5th of 2021 at $12.01, and one dated for August 9th of 2021 at $12.05. There is a June 16th, 2019, change of address from Houston, Texas. It was requested on June 3rd of 2019. Change of address from Fort Worth, Texas. That was also requested on June 3rd, 2019. What I do not have as evidence is a third request for a change of address from Houston for a time frame during which I had my address listed for legal purposes at a homeless shelter. Never received a notification of a change of address form. The Texas driver's license received in the mail. Driver's license dated for July 31st, 2019. Delivery from Harvard Business Services Incorporated, March 10th, 2020. Tax notice for my LLC, February 8th, 2021. Harvard Business Services Incorporated, pending tax due notice, January 25th, 2021. February 27th, 2021, Harvard Business Services Incorporated, personal agent fee notice due, February 18, 2021. March 8th, 2021, Harvard Business Services Incorporated, franchise tax due, February 24th, 2021. March 17, 2021, Harvard Business Services franchise tax info due, March 29, 2021. Tax and business agent fee confirmed is paid on March 23, 2021, after payment made on March 13, 2021. Also, the information regarding the formal incorporation, formally incorporated as of April 16th, 2020. Also, notices from Pacer, account set up September 25th, 2019. U.S. District Court, Northern District of Texas, response to initial filing September 24th, 2019. U.S. District Court, Northern District of Texas, response to filing January 16, 2020. U.S. District Court, Northern District of Texas, response to filing January 21st, 2020. Pacer, due amount August 17th, 2020. U.S. Court of Appeals for the 5th District, response to filing May 20th, 2021. Hand-delivered, quote, eviction citation dated for August 18, 2021. Letter from All Manned Law regarding important legal services advertisement concerning eviction proceedings, delivered on August 27, 2021. Postmarked August 26, 2021, eviction citation from Michael Orozco, dated for August 24, 2021. Postmarked for July 15, 2021, notice to vacate for holding over tenant at sufferance, dated for July 12, 2021. Received on July 15, 2021, notice to vacate for holding over tenant at sufferance, dated for July 12, 2021. Hand delivered. Printout of email from Goodwin Company to Martha Ellsbury in certified mail envelope with printout of email from Martha Ellsbury to Samuel A. Ellsbury and notice of April 29, 2020 concerning street parking during street resurfacing, dated for April 27, 2020, postmarked for May 1st, 2020. As part of the evidence, I say see U.S. versus Felix. 926 F2D 1522, February 28th of 1991, regarding same evidence can be used to prove more than one charge. This was submitted, or rather prepared by September 2nd, 2021. This would have been actual paper evidence. 3 of these are actually electronic records, electronic confirmation on the payments of concern that I contend actually provide a context to the information in the affidavit and would have been available and submitted as evidence in any legitimate proceeding. I do have all of those documents at this time, and when I went to the court yesterday, I had this as well as most of the documents with me. Other documents that I did not have with me would have been primary evidence in a proceeding and had already been engaged and would have first had to be used or acknowledged as primary evidence in those proceedings, and hence the same evidence can be used to prove more than one charge.